Good afternoon. Thank you very much for coming today. It's such an honor to be part of this distinguished panel. Today, my presentation is going to be about lack of judicial independence, the impact in transnational and international litigation, and specifically how to determine we are in the presence of lack of judicial independence. I'm going to divide my presentation into three parts. The first one is about what specifically is lack of judicial independence. The second part is about standards of certain types of transnational and international litigation that are relevant for the purpose of this presentation and for the purposes of litigators. And the third part is about how to determine the existence of lack of judicial independence. With that in mind, I'm going to turn into the first part of my presentation. What is lack of judicial independence? Lack of judicial independence in this context means that the judiciary doesn't work, that the judiciary is not complying its function, that the judiciary is one that is not reliable. A judiciary that lacks independence is a judiciary that is composed by judges who are subject to outside influence. That influence can be political influence or it can be economic influence. Political influence comes under the way of political pressure, political abuse, political favors, political advantages, or political instructions, whereby judges take decisions not as per the terms of the facts and the law applicable to the case that they have in front of them, but as per the political influence to which they have been subject to. Economic influence comes under the form of economic bribery, or economic favors, or economic advantages, or any other type of economic influence that makes judges take decisions outside the facts and the applicable law. It doesn't mean that the only influence that judges can be subject to is political or economic influence. In fact, it comes to my mind that one possible influence is the one that comes under the form of mass media or public opinion influence. However, to my knowledge, so far there has not been any case that have dealt with influence under the form of mass media or public opinion. To me, the bottom line to determine when we are in the presence of an influence that is pervasive to the independence needed in the judiciary is the bottom line that I'm going to refer to. And it is that the judiciary lacks independence when judges take decisions outside the merits of the case. So when that happens, then that's when we are in the presence of lack of judicial independence. In other words, judges need to be independent for the rule of law to prevail. And the rule of law is paramount of a democratic system in a civilized nation. The second part of the presentation is going to refer to specific standards in certain types of transnational and international litigation. Some of those standards have been referred by the colleagues that preceded me before. My colleague David Ogden specifically spoke about the standard referred to enforcement of foreign judgments in the US. I'm not going to dig into the specifics, but I think it's relevant to talk a little bit about this so we can understand why the lack of judicial independence is relevant in transnational and international litigation. In the context of enforcement of foreign judgments in the US, the standard does not refer specifically to the analysis of a specific case. Instead, it refers to an analysis of the whole judiciary, the so-called systemic analysis, whereby if the whole system lacks independence, then that's an important argument for a failure to enforce a foreign judgment in the US. In the context of the US, that standard has differed between the different jurisdictions that have considered this, and also over time. As David mentioned, the states that have adopted the Uniform Foreign Monetary Judgment Recognition Act basically follow the standard according to which for a foreign judgment to be recognized in the US, it needs to come from a system of impartial tribunals. Before the adoption of this act, as David mentioned, the Hilton case of the United States Supreme Court set up a similar standard, although it might look right now lighter in terms of strength that the specific standard referred to. In the Hilton case, the standard that was established was that the judgment that was supposed to be enforced needed to come from a system likely to secure an impartial administration of justice, and that nothing showed prejudice in the court or in the systems of laws. As you can see, the standard is somehow similar to the one established in the Act, but it had some additional ingredients that we don't find in the current standard established by the Act. In addition to that standard, the Osorio case, to which David referred to and in which I was involved, and for purposes of disclosure, I need to mention that I have been expert witness in many of the cases that I'm going to refer to, and some of the cases that have been referred to before. Specifically in the Osorio case, in the Sanchez-Osorio versus Dole case, the court, the federal U.S. court, established that in addition to the standard of analysis of a system of impartial tribunals, that analysis had to be conducted in practice. Specifically, the court said that the analysis was to be conducted not necessarily in the words of the law, not necessarily in theory, not necessarily in the text of the relevant statutes, but in practice, in reality. What mattered was how, in real terms, that judiciary was functioning. As you can see, whether it's a standard of the Act or the Hilton or the addendum that has been included in the Osorio case, bottom line is that for purposes of enforcement of a foreign judgment in the U.S., an analysis has to be conducted in the whole judiciary, and the whole judiciary needs to be a judiciary that provides either a system of impartial tribunals or likely to secure an impartial administration of justice. And that whole analysis needs to be conducted in practice.